Thank you.
Yeah, no, thanks. I'm going to deal with two, and then Dr. Shubur will deal with the rest. The call for Commissioner Love to resign, it's not a matter that the Commission has looked at, neither has Commissioner Love looked at the matter. So, personally, absent any substantive evidential material establishing misconduct on the side of Commissioner Love, then there would be no basis for such a resignation. Now, with respect to the Constitutional Court appeal, it is preferable to lodge an appeal when you have reasons, because then you can follow the reasoning of the court against whose orders you are appealing. But when an appeal is lodged against the orders of court, not against the judgment. And we have orders in this case, and on the basis of those orders, we think that there's a need for clarity on a number of issues. One, did the Commission go beyond its scope of authority in invoking Section 47(1)(e)? We have no clarity as a country on that aspect at the moment. Two, did Commissioner Love prejudge the issue to the extent that she ought to have recused herself? We don't know whether the statement that he made in response to a media question did in fact constitute prejudging the issue. Does remission of sentence amount to the reduction of the sentence as ordered by a court of law? We don't know. So those questions have to be answered for the clarity of everybody in respect of the immediate case, but also in respect of future elections. Are we not worried about violence? The Commission is always worried where the safety of people and the safety of property are concerned, because an election should never be an opportunity for people to lose life. It should never be an opportunity for people's property to be lost. It is rather an opportunity for the voter to record their political choices in an election that is arranged in accordance with the provisions of the Constitution and the law. So the Commission is clarifying those constitutional provisions that have a bearing on the preparation of the elections. And insofar as security matters are concerned, the security agencies of the country are responsible to secure all of us. And I'm sure they may be having plans to safeguard the election, to safeguard the election material, to safeguard the people, to safeguard the staff of the IEC, and to safeguard the property of all South Africans. Now, I think the two questions that I ought to answer have been answered, and we can give over to Masego to deal with the rest of the questions.
The first cluster of questions relate to identifiers on the ballot paper. Section 68 of the Electoral Act gives the Commission broad-ranging powers to determine the design, look and feel, and identifiers on the ballot. The Commission exercises that power based on an internal policy that does a number of things. One, it codifies practices as it relates to how ballots have been designed in successive elections. It also draws lessons from focus studies that we did with the Human Science Research Council to aid voters to be able to make their choice with confidence without inadvertently miscasting or spoiling their ballots. So the decision that a photograph of the registered leader of a party will be one of the identifiers is to be found in that policy of the Electoral Commission. And that has been a practice for successive elections up to now. The questions related to the judgment of the Electoral Court as it relates to South Africans who will vote abroad. Section 33 of the Electoral Act provides that voting stations overseas are the following: embassies, a consulate, or an office of the High Commission. The Electoral Court, having heard arguments before it, extended relief that says an honorary consul should be read in to mean a consulate. There are, however, still no reasons for that judgment. On our part, in order not to create perceptions that we are second-guessing or we do not comply with judgments of the court, we have written to the Department of International Relations and Cooperation, within whose remit the power to administer foreign missions resides, to establish from them the steps that they are able to take in the time remaining before the election to give effect to the order of the court. We have also asked the court for a full reasoned judgment and also noted a application for leave to appeal the decision of the Electoral Court to the Supreme Court of Appeal so that we get clarity on whether the ruling of the court accords with international law as it relates to diplomatic missions abroad. The signatures, an independent candidate or an unrepresented party, over and above submitting a list of candidates and paying a deposit, ought to submit a list of signatures. There are two steps. The first step is that that party or independent candidate first captures the ID numbers of the supporters onto the portal. Secondly, they must upload the signatures, hard copy signatures, onto the portal, or deliver those to the Electoral Commission. The Commission does not have a database of signatures, so it doesn't verify that the signature belongs to a voter. All that it does is to check whether the number of captured signatures are supported by the requisite number of signatures in order for a candidate to qualify. The parties that are still in court, there were in total 11 applications in the Electoral Court assailing either the timetable or alleging that the online candidate nomination system was dysfunctional to the extent that candidates or parties could not meet the requirements to submit. There is clarity as it relates to the 5 matters that have been dismissed by the Electoral Court. The court had 6 other matters yesterday. Substantially, the arguments are the same. The court has reserved judgment, and we anticipate that we will receive a order, even if we do not have reasons by late tomorrow, and that will determine when we start to print the ballot papers, because some of the matters still to be determined they implicate the configuration of contestants on the various ballot papers. The issue of material 95%, indeed we are 95%. If you consider the following, it takes 18 to 24 months to plan for an election. You don't start a few months before voting day. So the majority of requirements we have at hand. The only things that are still outstanding are related to ballot papers. You can't start ballot papers before you finalize the contestants. There is no truth to the report that we have asked for foreign assistance to provide for logistics at the diplomatic missions. The Commission will provide all the requisite materials at those voting stations. The last question related to observers and observer missions. The good practice internationally is that where you send observer missions are constituted by multilateral entities, for example, SADC, AU, or independent NGOs that are not part of a state machinery. Hitherto, we've never had to deal with a sovereign observing elections in another sovereign. We have observers, and in all elections we have accredited observers that came from multilateral organizations, NGO, and democracy building institutions. Thanks, Kate.
Thank you very much. May I request Peladi